We've spent over 22 minutes on this question. That's the end of the oral questions today.
Bill. We now resume the second reading debate on the Land Miscellaneous Provisions Amendment Bill 2014. Mr. Tony Chair, Chairman of the Bills Committee on the above bill, will address the Council on the committee's report. Mr. Tony Chair, thank you. President, as Chairman of the Bills Committee on the Land Miscellaneous Provisions Amendment Bill 2014, I would like to submit a report to this Council and also to set out the deliberations conducted by the Bills Committee. Under the existing Land Miscellaneous Provisions Ordinance, there are penalties provided for offences. The level of penalty has not been revised since 1972. The bill aims at increasing the penalty so as to increase the deterrent effect. Under the bill, occupation of unleased land would attract a maximum fine of $500,000 for the first conviction from the current $10,000 fine, and also for subsequent convictions up to $1 million. And there will be also the introduction of a daily fine. If the offense continues, then there can be an additional fine of $50,000 a day for first conviction, and for subsequent convictions, $100,000 per year. As for the offense of erecting unauthorized structures on unleased land, or the removal of stoned turf or earth or stoned, the maximum fine will be increased by 10 times. We at the Bills Committee, members generally support the legislative amendments in the bill because of the proposed significant increases in the level of penalties. Some members ask whether factors will be provided to the court for its consideration in determining the level of penalty for the sake of a greater consistency among different judges. The administration has advised that when cases are brought to the court, the administration will furnish relevant facts, including the size of the land occupied, whether the occupation involved permanent structures, and whether public safety was affected. From past experience, factors that the court will take into account would include whether the offender is doing this in a repeated offense, or whether a gain has been made by the offender out of the occupation. The administration is of the view that the more room should be given to the court to determine the level of penalty, taking into account the case circumstances. Some members are of the view that there should be better enforcement to tackle the unlawful occupation of unallocated and leased government land. Patrol should be stepped up. Modern technology should be used to detect unlawful occupation of government land earlier, and also enforcement action should be taken in a timely manner. According to the administrations, apart from acting on referrals or complaints, or as a result of patrols, the administration would also take other measures to step up enforcement. For example, adding more routes or changing the routing, and also to increase patrol, and also using aerial photos to assist in the enforcement, and better training will be provided to frontline officers. Some members have referred to a case whereby in a property transaction, some of the land purchased actually was government land, and the purchaser inadvertently committed the offense of occupation of government land. Those members asked the government to step up publicity to educate prospective buyers that they should be careful in buying land so that they will not be caught inadvertently by the law. It's important that the buyers should be knowledgeable about the relevant law. In response, the administrations indicated that they have recently aired radio and TV APIs to disseminate a message that unlawful occupation of UUGL will lead to serious consequences. And they also try to continue its publicity and public education efforts through different channels, including the Hong Kong Law Society, the Estate Agents Authority, and the district officers and the rural committee. The Bills Committee supports the resumption of second reading debate on the bill, and the Bills Committee will not propose any committee stage amendments to the bill. The foregoing is the report on the work of the Bills Committee, and now I want to express some personal comments. This bill indicates that the government is determined to combat unlawful occupation of unleased government land. Land is a valuable resource. Increasing the level of penalties will be able to will give us a greater deterrent effect, and to make sure that land will be put to good use. I support this bill. In scrutinizing the bill, I express my concern about Section 7, and that is the unlawful removal of earth, turf, and stone, and also the penalty of fine and imprisonment for such an offense. But it doesn't require the offender to reinstate the land with the earth, turf, or stone removed. And the definition of removal is unclear. For example, if someone moves the earth or stone in a river channel from one location to another, so that there's the diversion of a channel or the silting up the channel, would that come under the definition of removal? And I ask the administration to invoke other laws, other legal stipulations to enforce such prohibitions. The Bills Committee expressed concern that a purchaser of private land may inadvertently buy a piece of land which involves partly government land and may commit the offense of unlawful occupation inadvertently. The administrations responded by saying that they would step up publicity and to remind buyers to be aware of the need to clarify the status of the land. And I want to here mention the question of drawing up the boundary of the land. This is done through on-site survey and documentation. In the early days, surveying land in the NT and records kept are very sloppily done, because that was done to facilitate tax collection. And the equipment used back then, the techniques used back then, were not as advanced and sophisticated as what they are now. And therefore the boundaries are only rough indications, and the plans are simple and may not be able to indicate the exact boundaries. And very often the boundaries shown on the plan may not tally with the records, and it's difficult to ascertain exactly where the line should be drawn. This is the case of NT land. And in the past, they may use the dividing embankments as a reference to delineate the boundary. Such objects or structures may have already disappeared. So the early records of land plans and records may not be able to meet modern day needs. So private land, in the NT, from time to time we have these disputes arising from the delineation of boundary and status. These surveying community have asked the administration to do the survey again so that we can confer a legal status on the new plans and boundaries to take the place of the less than accurate records in the past. And then we can make sure that records would commensurate with the records and maps, and then we can prevent a buyer from buying land with involving government land, and we can also avoid the disputes and possible litigations. What's more important is that we will be able to do away with the problems of unclear or inaccurate boundaries of NT land, and by doing this, we can use land more effectively. I hope the administration will take this up. And I think the government should also step up public education and publicity. Buyers should be reminded that when buying land, they should seek professional advice, especially the advice from the professional surveyors, and the need to ascertain the boundary of the lot purchased. This bill is about increasing the levels of penalty. I think the government should also step up enforcement and patrol of government land. The administration said during the scrutiny that for unallocated and unleased government lands can be found in many districts, and comprehensive patrol will not be feasible. But if the government only carry out a patrol upon receipt of complaints or referrals, this is rather reactive. The administration should take a multi-pronged approach. There should be suitable staff deployment. Apart from on-site inspections, there should be more measures. For example, we should make use of modern technology for inspection or monitoring so as to make sure that such enforcement action is more efficient and enforcement will be more effective. I hope the administration will take up relevant measures to enhance enforcement. If government land is occupied extensively, and if land is not managed properly, then in the future, when the land is needed for government projects, many problems will be created. For example, you need to reallocate or rehouse the relevant occupants. The government should not brush aside the problems lightly. So I submit.
Mr. Chi-wai. Thank you, Mr. Deputy. The purpose of the bill is to increase the penalty for illegal occupation of government land. The Democratic Party is in support of this because this will combat the fly tipping and also illegal occupation of government land in NT. Previously, the penalty was negligible and it couldn't stop any fly tipping. I hope that this will achieve a deterrent effect. The mere increase in penalty will not be sufficient. To improve the situation, we have to rely on the law enforcement of the Lands Department, the way in which law enforcement is taken. In 2010, the Director Audit Report mentioned a case in Yunlong which illegally occupied government land for 18 years, and the government hasn't enforced the law to require reinstatement of the land. I handled a case in which a barbecue pit, barbecue site was erected on government land. The government issued a letter for the site to be removed, and the government threatened to repossess the land. But as of today, the person hasn't really reinstated the land. If the Lands Department is not enforcing the law properly, how can we have any confidence in the government enforcing the law? The other thing is law enforcement. In 2012, in the Direct Audit Report, there was a mention of the IT system of the Lands Department, that the mobile devices would facilitate law enforcement. The Lands Department said that they will explore this possibility. 2 years on, no action has been taken. The official said in reply that this would be considered. And they said that there would be results by the end of 2014. I'm not sure whether the government has any reply to this. If they are not ready for that, it would highlight precisely the problems. The government is not interested in identifying devices to help them with the enforcement. However many legislation we enact, it will be difficult for us to improve the situation and stop government land being occupied illegally. Let me reiterate the question I put at that time. Does the government feel that the Lands Department, through visual inspection, through the survey maps, would be in a position to tackle the problems? Isn't there any better way, using IT, to tackle the problem? I doubt very much whether the government has sufficient information regarding the situation. In October 2013, Mr. Albert Ho of the DP raised an oral question urging the government to provide us the information on government land in 6 OZP. And the government said that the government hasn't got any land record regarding government land in the OZP, so they're not in a position to provide the information on government land in the 6 OZPs and the use of these sites. According to the Lands Department, in these 6 OZPs, the area zoned as open storage and agricultural land, they are really scattered, and they are in the middle of private land, and a lot of them have short-term tenancies, streams and graves and so on in them. Why is it that the Lands Department is merely giving us the observation instead of the information from the map? When we scrutinized the bill, we kept asking the government, with the increase in penalty, how can they make sure that the Lands Department officials will have the most up-to-date information? Without any aid, any technical aid, it would be difficult for them, just from visual observation, whether the scattered land is government land, whether they have been occupied illegally. Isn't it right for the Lands Department to change its attitude and its determination? If this doesn't happen, it will be difficult to inspire any confidence that the government is going to combat illegal occupation of government land. Obviously, like Mr. Tony Jay said, the surveyors wrote in the newspapers about the surveying in the NT. That took place between 1890 and 1905. According to the article, the surveying was done manually, and that was the government lease, the Crown lease. Now, how can we make sure that there is no discrepancy at that time? If the surveying is called into question, why is it that the government has any confidence that through visual observation they will be able to get the information right? Finally, I hope that the administration will rectify its attitude towards illegal occupation of government land. In 2010, the then Secretary for Development, that is the CS now, Mrs. Carrie Lam, said in reply at that time that managing government land, in particular land in the NT, is not a simple task. Government land is all over in the NT. It is difficult for the Lands Department to conduct inspection on a regular basis. The resources will be used on the basis of complaints and media coverage. It is only reasonable that action be taken on this basis. I fully appreciate the complexity of government land in the NT, and also the surveying techniques were really so backward. If the government feels that the best way to deal with illegal occupation of government land is on the basis of complaints, then it would mean that the government is not doing a good enough job in gatekeeping, and they are inadvertently encouraging illegal occupation of government land. This piece of legislation is intended to increase the penalty, but it would be very difficult to achieve the desired effect. So if the government feels that to tackle illegal occupation of government land, there is a lack of resources, then the government should seek more funding, more resources from the LegCo. If you feel that visual inspection is not the answer to the problem, then obviously you have to tell us in no uncertain terms that the government is exploiting best technology like satellite, GPS, and so on to ascertain the exact location of irregularities. And the government should really get the culprit instead of getting the wrong person because of the poor surveying work. The government should do something about the situation to resolve the problem. The amendment to the Land Miscellaneous Provisions Bill is only the first step of a long journey. We have to make sure that land in Hong Kong or land all over the NT will be covered by better surveying exercise, and we should have the right map. The government has an obligation to get on with the surveying to ascertain the standard of surveying which would be acceptable to all parties concerned. Thank you.
Thank you.
Mr. Kwok-hing. Thank you, Mr. Deputy. I rise to speak in support of this bill, the Land Miscellaneous Provision Amendment Bill 2014. The bill is tabled because of a serious illegal occupation of government land. In 2010, there were more than 10,000 such cases. In 2013, there's more than 11,016 cases. So we're seeing an increase over the years of the illegal occupation of unleased and allocated government land. The current law is not a good deterrent effect. It's not presenting a good deterrent effect. So under the bill, the penalty will go up by 50 times. So instead of $10,000 in fine, on first conviction, the maximum fine will be $500,000. It looks a very high amount, a big amount. And also on each subsequent conviction, the maximum fine can be doubled. But the imprisonment term will remain unchanged. It's still 6 months under the bill. So I think although the bill can increase the deterrent effect, it's still a limited effect. The administration should consider or should monitor whether after the passage of the bill, the intended deterrent effect can be achieved. If not, the fine level should be increased, and the imprisonment term should also be increased. Under the bill, illegal occupations, dumping, erection of structures, or illegal development of land will also be subject to penalties which are effective. For example, extraction or removal of earth, turf, or stone from government land. Removal, and that is, in common people's language, developing the land illegally, will be an offense. There should be more publicity that if people remove earth, turf, or stone from government land, it's an offense. Public education should be stepped up, because many people might have committed such a serious offense inadvertently. In the past 2 years, we have had more than 10,000 cases. As a former member representing West NT, back then I received many complaints concerning the illegal dumping of earth on land, and they were nuisances to many people, and very often the earth cannot be removed, and the complaints cannot be addressed. So with the passage of this new bill, what is needed for the next step is law enforcement. The administration should step up enforcement. Otherwise, we are going to see only some limited deterrent effect. I have a few suggestions on how to step up law enforcement. I hope the Secretary and the relevant departments can take them on board. There should be regular aerial photography so that you can gather information to cross-check with your information system. It should be done proactively. Through aerial photos, you can see the changes on government land. This would make up for the manpower shortage. And there should also be high-rise patrols. Mr. Deputy, modern technology has advanced rapidly. For example, we have unmanned airborne drones available, and it's widely used in photography. The government should update its equipment, adopt advanced technology, and use unmanned airborne drones widely, so that the government can monitor government land more effectively. But of course, the use of airborne drones should be carried out without affecting aviation traffic. The district land officers should be asked to monitor government land in those districts and to make up for the shortage of manpower. Very often, it takes a long time for the administration to respond to complaints. And there's no pledge made on the response time. And the government should give a pledge so that you will promise how much time will be needed to respond to a complaint, and to sell out in clear terms what can or cannot be done within a time limit. There should be a performance pledge. I also want the administration to monitor black spots of illegal dumping. This is particularly serious in the new territories. All of a sudden, you can see a lot of earth dumped onto agricultural land or government land. Some unscrupulous people do this to save the cost of transporting the earth to a landfill. I think CCTV should be installed so that the culprit can be apprehended. And also, lastly, I would urge the administration to increase the establishment of the Lands Department. Illegal dumping on government land, illegal structures on government land, and illegal development on government land are serious. And very often, the buildings department is suffering from a manpower shortage. There were protests by the staff they took their complaints to the director, saying that they were short of staff and could not handle all the cases allocated to them. If manpower is not increased, then the enforcement can only be done to a limited extent. So, Secretary, please look at the vacancies in the relevant departments, and you should apply for such vacancies to be filled. And I think you have the counsel of this council, because what they do will be beneficial to people's livelihood. After this bill is passed, the administration should also review the law regularly. So 1 year, 1.5 years after the new law is implemented, a review should be conducted. The administration should ascertain whether the new law is effective in tackling illegal occupation, and also look for room of improvement. There should be regular reviews. And the administration should consider whether the imprisonment term should be increased. Would the current maximum term of 6 months be sufficient? There's a need for regular reviews to be conducted. Mr. Deputy, the administration tabled this bill because in May 2012, the Public Accounts Committee deliberated on the findings of the Director of Audit report number 58. I don't think the administration should wait until criticized by the Director of Audit. You should find a solution whenever a problem is identified. So that's why I'm saying that there should be regular reviews. I hope to get a response for all my suggestions in this exercise. Thank you.
Dr. Kenneth Chan. Thank you, Mr. Deputy. We all know that in Hong Kong, land is a precious public asset. Always the government said that it would like to identify land sites for development and housing production so as to meet the public demand for housing units and for home ownership. So any person, any company or institution, if it occupies any land is actually tantamount to robbing public resources from the public. So the Civic Party strongly supports the government in enacting this amendment bill and to enhance penalty. Now, if you look at this bill, you see that today the penalty system is already 41 years old and has never been modified. 41 years ago, the price of a cup of milk tea was very different from now. We've got hefty inflation, so if we maintain the same penalty system is unfair. In particular, those who rob land from the public, be they in the rural areas or be they unscrupulous companies, they can earn the same amount very soon. From 2008 to 2013, breaches under this ordinance, Section 6(4), and the 58 convicted cases, penalty ranges from $500 to $10,000, and the average fine per case is around $4,700. And in 6 cases, the highest fine was handed down. And land area occupied varied from less than 1 square meter to 4,600 square meters, $500 to $10,000, a very small sum of money. For the unscrupulous businessmen, very quickly, by way of unscrupulous means, can get back the money very soon. So the Civic Party supports this amendment bill and the proposals therein in relation to unauthorized occupation of public land. In the scrutiny process of the bill, we repeatedly reminded the government to proceed with legislation and enhance penalty. But if the government has not done enough in terms of law enforcement, then the deterrent effect won't be enough to curb such unscrupulous occupation of government land. Here I'd like to cite some examples. Day after day, we see these unlawful columbarium facilities. In Two Moon, we got one. On a prolonged basis, I've been following up on that case. And in last year's budget debate, I asked the Lands Department a question on the same issue. For that Two Moon monastery, the Lands Department carried out 55 inspections. The first time of the breach discovered involved 1,280 square meters, and 7 statutory notices were sent. At least there were 7 fines, and the area occupied decreased from 1,280 square meters to 140 square meters. As a result, the residents there asked whether it is really a monastery or a place that terrified people by their fierce members. So by enhancing penalty and by way of education and publicity, we would like to curb such unscrupulous acts and wrong culture. If you step up patrol and law enforcement, then, well, if you don't do that, you'll be saying one thing and doing another. You are the gatekeeper. You should guard our precious public resources. So if the government officials fail to do all these, we should criticize them. So the government should come back and tell us how law enforcement is to be enhanced, the resultant deterrent effect, and the whole impact of this exercise, this amendment exercise. Now, in the course of our scrutiny of the bill, we discovered that in many of these suspected illegal occupation of government land and unscrupulous removal of earth, turf, or stones from unleased land, we relied on public reports. The government received 10,000 odd and 11,000 odd reports in 2012-2013 in relation to these unlawful acts. How did they discover this? In 2012, we got 393 cases, 2013, 416 cases. Well, they carried out risk-based patrols. Now, resources are limited. We have to have value for money. We have to talk about efficiency. So, for these risk-based patrols, they are a must. If members of the public proactively lodge complaints, the government departments have to cope with appropriate measures and actions. We need to have technical support. We should have aerial imaging and photography. And we should also enhance this risk-based patrol system. And after this exercise, when penalty is enhanced, we should assess how this has been effective in curbing unscrupulous occupation. The government should also consider, after enhancing the penalty, how, by way of education and publicity, members of the public can be enlisted to assist the government in curbing this wrong culture. Well, don't just tell us the government is doing things. Tell us what resources are spent on gatekeeping and to what extent the government has been doing gatekeeping. Should members of the public play an active role? Yes. The government should enhance publicity and education to assist members of the public to know how to identify suspected cases of illegal occupation. Are there easy and convenient methods to tell whether a site is a piece of government land or a piece of private lot, such that when the public have suspicion, they can assist the government in terms of patrolling, law enforcement, and prosecution? Can you also clarify, on government sites, you sometimes have fenced-off sites, can you enhance signage and display notices such that the messages can be correctly sent to the public? Well, if members of the public have these notices and information, if they spot any occupation of the sites, they will be able to differentiate whether or not the act is unlawful. And such display mechanism should be further clarified, and maybe we should have more such notices. Otherwise, we have to find all these information out ourselves. We councillors sometimes have to inspect the lot concerned to see whether we can make a differentiation. And the government should also simplify avenues of complaints. And members of the public should be able to proactively lodge complaints to government departments so that they feel at ease in doing so. They'll feel that the government is eager to address their concerns and complaints. There should be more avenues. There should be more publicity. By doing so, you can effectively assist members of the public to help the government in its work. And then for private land transactions, as the government said, this is not the government's business, but we do not want potential buyers to discover such unlawful occupation only after the purchase, then they will be very disturbed. Of course, the major responsibility lies with the buyer and the purchaser, and then they should enlist assistance from the professionals and experts. And at the end of the day, they have to bear the risk and liability. But the government should step up patrol, and to cope with public complaints in curbing this unscrupulous culture. And the government should seek assistance from professionals like surveyors, such that they can help with, say, publicity, so that they can also act accordingly to match government's efforts. And through intermediaries and similar companies, they should explain the risks to the potential buyers such that before they make a decision, they can act properly and carefully. And then in the course of our scrutiny of the bill, we learned that the government had been considering regularizing certain regulatory mechanisms. Well, this seems to be an abstract concept which may not be easily understood by the public. Well, it's unlawful, it's occupation. Why should all these be regularized or tolerated? Why should contracts be signed for these people to continue to use the unlawfully occupied sites? Well, to the government, this is nothing usual, nothing normal. I think the government should clarify the criteria to be adopted such that members of the public will understand. And the unlawful occupiers won't have this misconception that by occupying the land, they can force the government to negotiate with them. That is, unlawful activities may become regularized or tolerated. And then no matter what education or publicity you do, you end up with nothing. So on the one hand, I prosecute you. On the other hand, I fetch you to negotiate with me. Now, the government must make it very clear that this will only be done under very, very exceptional circumstances. Otherwise, everybody will like to try their luck. And many people in the rural areas may continue with their occupation behavior. So the Civic Party would like to urge the government to continue to step up law enforcement. This is just common sense.
Mr. Gary Chen. Thank you, Mr. Deputy. The Chair will rise to speak in support of the Land Miscellaneous Provisions Amendment Bill 2014. Mr. Deputy, I'd like to say something about the penalty, which is proposed to be increased. Like many members said, this bill is intended to address the lack of deterrent effect of the current level of penalty, and the administration is putting forward this bill to increase the penalty, and this is a clear message from the community. During the deliberation at the Bills Committee, we have the bipartisan, of course, party support. The Amendment 64 seeks to up the penalty 50 times, and there is another element of the daily fine. Now, for those who are determined to occupy government land, we have to apply the full force of the law, and that much I agree. But there are some investors, there are some members of the public who might be caught inadvertently by the bill. The Law Society did raise this particular concern. The bill is rather straightforward, but at the Bills Committee, we tread it particularly carefully. I mentioned the daily fine. Some members said that the occupation of UUGL, unleased and unallocated government land, these occupiers may not be fully aware of the penalties or the offences they have committed. According to the administration, for illegal occupation cases, the government would first of all issue the notification for the cessation of occupation. By the time the notice expires, if the activities do not cease, then there would be an additional daily fine to the tune of $50,000 on a daily basis. If someone has been convicted and still flout the law, there would be a daily fine of $100,000. This is no small sum of money to the general members of the public. Now, the one-off fine would be $500,000. If I occupy the land, let's say, for 10 days, then I would be slapped the maximum penalty of $500,000. And that in itself would achieve a very good deterrent effect. As I said, for those who are determined to occupy government land illegally, then the more penalty, the higher penalty, the better. But for the general public, I think we have to be careful. We have to make sure that those who are inadvertently caught by the law will be taken care of. At the Bills Committee, I highlighted this particular concern. I saw that there may be some people who are innocently unaware of illegally occupying the land, and in fact, in some cases, they purchase a piece of land and they are innocently unaware of any illegal occupation. This kind of penalty would impose a very heavy burden on them. In reply, the government said that there would be two considerations. First of all, for those who are illegally occupying government land, there would be a defense, there would be a period for which to give the justification. There would be a notification period. I hope that the government would give a reasonable period of notification so that the problems can be rectified with a long enough period of time instead of being slapped a daily fine of $50,000 and $50,000. Now, in the course of our debate, and indeed at the Bills Committee, some members said that the mere increase of penalty without law enforcement would not be sufficient. I agree. In reply, the Lands Department that inspection will be stepped up, and there would be risk-based inspection. They may exploit the latest technology like aerial photos, and also more training for the frontline staff. All these are in order. But if you just increase the resources and you're not taking full advantage of the inspection results and take enforcement action, then it would not be of much deterrent effect. I hope the Lands Department will enforce or implement all these measures. If they identify irregularities, Mr. Secretary, you have to instruct your staff to take enforcement action. Also, as members said, please come back to the development panel on a regular basis to bring us up to date on the implementation of the above measures. Thank you.
Ms. Sitho, thank you, Mr. Deputy. This amendment bill is a response to the Director of Office report in 2012 that there has been occupation of government land that went unpunished. We welcome the amendments. Some anti-small houses are built on a slope, and therefore they need 150 square feet of government land to build a flight of stairs, 10 or 8 or 10 steps for access, and then there will be and the land can only be good enough for some flowers to grow on, and the rent is $3,000 a year. But if we look at the old penalty levels, it's just a maximum of $10,000, and there's no daily fine. They might as well pay the fine, because it takes time for the case to be detected. There was a lack of manpower, and then the government didn't know where to put the notice if the government land was surrounded by private land, and then you need time to get the case to the court. So paying $10,000 might be cheaper than paying government rent properly. This time, the government proposes to increase the penalty by 50 times. We support that. And then there's also the introduction of a daily fine for as long as the offense continues. We support this too, because otherwise there will be no deterrent effect. The cases uncovered by the Director of Audit included the use of government land for recreational uses. So on a piece of government land, some structures were erected, and the case was exposed. The structures had to be demolished, but the occupier resisted fiercely, and he threatened that he would fight the government to the very end. The government land was surrounded. It was like an enclave. It was surrounded by private land. So access to the government land involved passing through private land. And it's difficult to deal with illegal occupation like this. If there are government land surrounded by private land, it's difficult to detect illegal occupation. So we asked why there was such enclave sites. Did the government try its best to avoid such enclave sites being created as a result of land sale? The government should prevent this from happening again. It's impossible to ask the Director of Lands to send people to patrol all the land in the NT. So we have advised the government to use aerial photography or some remote controlled devices to monitor land use. And after detection, there should be effective follow-up action. Otherwise, it's just effective in gathering information. It doesn't really offer help because you cannot bring the offender to justice. We were told by the officials in the Bills Committee that the records kept by the government on the boundaries of government land were not very accurate, and there was insufficient manpower to accurately register or record the boundaries of government land. So there may be problems. A purchaser might have purchased a site and part of it is government land. He shouldn't have paid any money for that government land. And when the case came to light, the land will be recovered and the purchaser would suffer a loss. actually the professional people who offer the service in the transaction should bear some of the responsibility. Not everyone can afford the kind of costs incurred by the CE in engaging professional people to advise him. So ordinary people are supposed to be law-abiding. So if a case of a mistaken occupation like that happens, who should pay for the cost? I think the professionals who assisted in the land search should avoid such cases because they have the expertise. But the professionals might not be able to overcome the difficulties presented by poor government records. Because the professional might have looked up one record kept by the government, but then maybe the need to check one or two more previous records in order to ascertain the status. So the right solution lies in the deployment of suitable resources to make sure that the records made available for inspection by professionals are accurate. The professionals who has made the best endeavor in record checking, which are not accurate, may not have to bear any responsibility. So the ultimate responsibility lies with the government. I hope the Secretary, in responding to our speeches, would say something about whether there will be any follow-up action to tackle the inaccurate records kept by the government, so that there will be no loss incurred by a buyer who inadvertently purchased a site which is partly government land.
Mr. Albert Chan, Mr. Deputy, I speak in support of the second reading of the bill as well as the principles and spirit behind the bill. Yet I have to send a clear message to the government. The land administration regime at the moment is very much flawed. In terms of administration, there are a lot of problems. And this problem of occupation of government land varies in severity. In certain cases, the occupiers do not have any benefit, but in some other cases, the occupiers are benefiting hugely. So if you're not careful enough, you may target the wrong persons. So you must have clear provisions as well as enforcement details. That's very important. Very simple. For many, many years, I handled many cases. For some morning hikers, they love to grow plants by the hillside. Say when they walk past a particular spot, they grow something there as a hobby. They water the plants and go back later. So they make the place quite beautiful. So the government is worried that if they touch upon the slope, landslide may result. So very often, these plants grown very carefully by the morning hikers were removed, and then the government sites concerned were fenced off. In certain cases, government action was really absurd because slope safety was not undermined at all. A few years ago, I handled some complaints from the rural areas. Some residents place a flower pot in front of their house, and the lands department removed those flower pots. I went down personally to talk to Lands Department staff as well as the elderly lady there, because that was alleged to be unlawful occupation of government site. And in Tuen Mun, repeatedly I was also accused of unlawful occupation of the sort. Some years ago, I owned a village house. If you rely on the government to come and remove the undergrowth, they only came once or twice every year, sometimes not even once a year. And then just 3 to 4 feet in front of your house, you got these 6 feet tall plants or grass. And in fact, I never prohibited any person to use the site. But then the media reported that I unlawfully occupied government site. And later the government allowed me to pay a rent to occupy the site. In fact, many residents in the rural areas are willing, well, if the government so willing, to let members of the public grow flowers or plants on those sites. But very often, when you want to rent government land under a short-term tenancy to grow flowers, you have to go through a number of hurdles. The family in front of my house have been applying for over 10 years, but in vain, due to objection from the villagers. They've been growing plants there for many years. Still, the government rejected their application for leasing this site of 100 square meters in area for growing certain plants and flowers. And sometimes the government is lopsided in its policy, and there are these rich and powerful people whom the government favors. Some village representatives have been fencing off sites for the growing of fruit trees. When a complaint was lodged, it said that this VR was assisting the government to protect government land. But in fact, he fenced off the site for his own purposes. The Lands Department subsequently replied that he is just assisting the government to guard government land. But think about that elderly lady. She was not allowed to do so. So you see, the rich and powerful persons can affect government interpretation on the use of land. We observed huge discrepancies. If you've not been personally handling those cases and experiencing the situation, you'll find it difficult to understand why there should be such huge discrepancies in law enforcement by government departments. And then there's this example of Pui O. On Saturday, some green groups went to have another look. There we have a piece of wetland with the buffaloes. For over 20 years, people were living there, and illegal dumping of wastes have caused the condition of the wetland to deteriorate tremendously. Well, yes, some lots belong to the villagers, but there are government lots as well. I wrote to the Lands Department, copied to the EPD and so forth. They replied that they would patrol the area, but they could not have 24-hour patrol. They cannot patrol the area around the clock. And how can you prevent illegal dumping? Well, they're not actually occupying the area. That's a beautiful piece of natural wetland. But you can see that this habitat for the buffaloes has been halved. Well, half of this Puyo wetland is gone. Just go to have a look. Well, it's rather exaggerative. On farmland, then, we saw the stacking of containers. Half of Puyo the wetland near the waterfront have now become a storage area for containers. And of course, there are also private uses. Originally, we had beautiful natural scenery there. In the past, now TV and cable TV had produced special programs and episodes to publicize Puyo as the natural, beautiful habitat for 40 to 50 buffaloes. But now, the area has been damaged, and as a result of a diminishing habitat, the buffaloes there have been seeking food everywhere. We absolutely want to empower the government to enhance its law enforcement powers. However, there are gray areas. The powerful persons can do what they want. The Lands Department is in a weak position. And then for the disadvantaged, you threaten to arrest them. Say for that 70-year-old lady, the Lands Department asked her to remove her flower pots. The flower pots had been there for decades. It's all because the powerful persons were lodging complaints. So by way of this amendment bill, I'd like to reflect all these to you. Recently, an old Kai Fong in Chunwan, in Chow Kong Tam, he grew plants for 40 to 50 years. Previously, those were squatter huts by the hillside. After demolition of those squatter huts, they were relocated to PRH estates, and then they went back to take care of the bananas and the fruits. You see, once the fruits were ripe, people removed them, and then the Lands Department fenced off the site. Well, they've been growing the fruit trees there for decades. They rely on them for a livelihood. They labored a great deal to grow those fruit trees. And then the Lands Department fenced off the sites. Yes, in terms of the jurisdiction of the Lands Department, in terms of laws, yes, you're correct. But they didn't hurt anybody by growing banana trees there. Nobody went to the banana orchard. Nobody was living nearby. That's a site for mature fruit trees, banana trees. It's an orchard, actually. And they've been managing that orchard, so to speak, for decades. The acts of the Lands Department caused them to cry. Well, they cannot keep a continuously vigilant watch on the orchard, but once they go away, people take away their bananas, and then the Lands Department fenced off the site. Well, this is a matter of policy. If you have a policy to allow such activities to exist, if you have proper policies, then injustice can be rectified. Well, let me go back to unlawful occupation of government land. Well, I've been living in a village for many years. Now, it's very interesting. Village areas. Well, I love greening, so before I rented the government site, I formed the land and then grew flowers there. But many villagers don't love grass. Once they erected their houses, they put concrete on the land surface. But they're not considered as unlawfully occupying government land. Well, they place tables on the concrete land and then smoked they sat there. Well, in fact, they're also unlawfully occupying government land. But I never saw the Lands Department enforce the law there. They never erected a notice there to say that those villagers were illegally occupying government land. But for me, I grew flowers there. I was accused of unlawfully occupying government land. Of course, some people don't want to take care of plants, which may attract insects and mosquitoes. So the local villagers love to pave the land with concrete. But that may not be conducive to greening. It may not be helpful insofar as environmental protection is concerned. And this elderly lady placed flower pots in front of her house. The Lands Department said that she was unlawfully occupying government land. So between bureaus and departments, I believe they have to sit down to work out some policies. Statutory provisions are rigid. Can you make village environment or in special circumstances do something? We're saying Mr. Chen Kam-lam got 2 concrete pillars in front of a house to place flower pots. Well, the newspapers reported that. I don't know whether or not the Lands Department had already acted on that. So you have to consider village management such that government land could be put to proper use. It is impossible just to rely on the Lands Department to manage all these sites. The Lands Department does not have the money to clear the undergrowth frequently. They cannot always patrol the sites. So you have to have a policy for village management. What about those unlawful occupiers who use government land for columbarium services or facilities? You allow them. You tolerate them. And for others, when they do something to improve the environment, you enforce the law. So I would like to have some proper enforcement.
I would like to express my support for the resumption of the second and third readings of this bill. In deliberating also as the chairman of the PAC and in the findings of the report number 58 of the Director of Audit concerning the management of government land in May 2012, the Public Accounts Committee expressed its opinion that fines for offences committed under Section 6(4) of the Land Miscellaneous Provisions Amendment Ordinance were too lenient to have an adequate deterrent effect. The PAC strongly then urged the government to promptly initiate legislative amendment to increase the level of relevant penalties and to consider introducing a system of daily fines to reinforce the deterrent effect. And now you're now doing it. However, while I support this bill with the aims to increase the penalties for the offences relating to the unlawful occupation of unleased land, unlawful erection of structure on unleased land, and the extraction or removal of earth, turf or stone from unleased land without a removal permit, the Bills Committee has considered the existing enforcement action undertaken by the Lands Department. Yet, as well as increasing the level of penalties, I am concerned about the enforcement actions taken by the government. If they are not backed by effective investigation and prosecutions, these penalties will be mere words with no actual impact in stopping the unlawful occupation of unleased land. Therefore, during the Bills Committee meeting, one of the main topics discussed was how to enhance the effectiveness and efficiency of the enforcement actions. Based on information provided, the administration receives or detects cases of suspected unlawful occupation of unleased and unallocated government land, UUGL, but short term, largely through complaints or referrals. Yet it is apparent that the overall situation of unlawful occupation of the unleased and unallocated government land may not be fully reflected by these complaints and referrals. The government claims that it would not be practical or cost-effective to patrol all UUGL and only encourages citizens to report cases and conduct risk-based patrols that focus on fenced-off or black spot sites, which are relatively more vulnerable to unlawful occupation, as well as those that have a frequent history of complaints. Such an answer is not the best nor the most desirable response, given that the Lands Department is the sole department responsible for the management of government lands. I believe it should take a more pragmatic and proactive approach by stepping up patrols and site inspections. Indeed, the administration have introduced measures such as updating and expanding patrol routes, increasing the frequency of risk-based patrols, making use of aerial photos and providing training to frontline and investigating officers. Nonetheless, I still urge the administration to conduct timely reviews and to report to this Council to ensure the efficiency and effectiveness of these aforementioned measures. Another major concern of mine, as highlighted by my honourable colleague Ka-lok, is the possible measures to help prospective buyers of land or private properties who inadvertently committing the offence of unlawful occupying UUGL. The Bills Committee has focused on these measures in order to provide better protection for prospective buyers, helping them to avoid offending due to ignorance. Indeed, during the Bills Committee meeting, the administration committed to stepping up its publicity and public education by reminding and sending out messages to the public not to engage in unlawful occupation of UUGL, and to seek professional advice before formally entering into transactions. The government also committed to working out with stakeholders and professionals such as the Law Society, the Estate Agents Authority, the district officers and the rural community. However, I cannot agree that the government should only focus on investigation and prosecution while sending private parties involved in UU government land transactions to court. Instead, it should work together with the aforementioned stakeholders and professionals to design a code of practice and guidelines to provide sufficient evidence and protection to prospective buyers of land or private properties. With this, I support the resumption of the bill.
Does any other member wish to speak? If not, I now call upon the Secretary for Development to reply. The debate will come to a close after the Secretary has replied. Secretary for Development. Mr. Deputy, first of all, I want to give my heartfelt gratitude to Mr. Tony Chia and other members for their scrutiny of the Land Miscellaneous Provisions Amendment Bill 2014 and for the support that they have given to the amendments in the bill. And also thank them for their valuable comments and input in respect of the bill. And 8 members have spoken on this bill. I thank them all. On the 9th of July last year, when I tabled this bill in this council, I mentioned that land is a scarce resource in Hong Kong. The government must make sure that land is properly managed. Under the Land Miscellaneous Provision Ordinance, Cap 28, there are penalties for relevant offences in respect of occupation of government land. This is an important part of our enforcement system.
修訂加重與不合法佔用未批租政府土地相關嘅罪行嘅罰則，以加強阻嚇嘅作用。修訂建主席容許我扼要咁就修訂嘅內容簡介一下。條例第6條 規管不合法佔用未
For unlawful occupation of unleased land, Section 6(4) stipulates a fine of $10,000. This has never been adjusted. So the present fine is not commensurate with the severity of the offences concerned. For the first offenders and the repeated offenders, this is not strong enough in its deterrent effect. In the 2012 report of the Audit Commission, it suggested that the government enhanced the penalty and as well as the daily fine in order to enhance the deterrent effect. As for the other relevant provisions, they include Section 6(4)(a) in relation to the regulation of erection of structure on unleased land, as well as Section 7(4) on removal of earth, turf, or stone from unleased land, which is similar to Section 6. The penalty cannot reflect the severity of the offences concerned and have not been deterrent enough. So the administration proposes an enhancement of the penalty by introducing a daily fine system. When we drafted the amendment proposals, we took reference from other pieces of legislation in relation to similar provisions, like Cap 123 and Cap 131, Town Planning Ordinance, and Waste Disposal Ordinance, Cap 354. In terms of land administration and land planning are closely related. Under the administration regime for UUGL, it's actually similar with unlawful development. So we use the penalty for unlawful development as our basis in this exercise. For UUGL, that is, for Cap 6(4), the government proposes that the first offence should attract a fine of $500,000 with a daily fine of $50,000. And then for any repeated offence, upon conviction, the maximum fine should be adjusted to $1 million. And for a continuous offence, the daily fine should be $100,000. As for unlawful erection of structure on unleased land and unlawful removal of earth, turf, or stones from unleased land involving Section 6(4)(a) and Section 7(4), the administration also proposes a corresponding enhancement of penalty. Besides, the court can proactively or upon application by the administration issue orders to the person concerned to request that person to pay all those fees and charges incurred under Section 6(4). During the scrutiny process, members of the Bills Committee were in general in support of the proposals. At the same time, on land administration and management, members of the Bills Committee had offered us a great deal of invaluable advice and suggestions. Land administration and management are very important tasks. In fact, the Lands Department has already adopted measures to enhance land administration and management. For example, they've enhanced their information dissemination system, expanded their patrol routes, increased the number of risk-based patrols, and increased the number of staff members involved in the task, as well as enhanced training. The department has also introduced new science and technology to enhance the efficiency of law enforcement. Equipment under use include aerial imaging instruments as well as unmanned devices for aerial photography. For example, government lots surrounded on all sides by structures. They can also for remote inspection. The Lands Department will introduce other technology for patrol. For example, handheld devices can allow their staff members to immediately obtain land information, and surveying devices carried on staff members' back can assist them to get more information, and 3D laser devices can provide perfect 3D imaging records to facilitate future inspection and prosecution. At the end of October last year, TV APIs and audio recordings were produced to disseminate the message that UUGL is very serious breaches of laws. All these were put up in district land offices, district offices, and the officers of rural committees. We also sent the notices to Reader, Hung Yi-Cook, and relevant bodies to urge them to alert villagers to possible illegal structure or UUGL on government land. Potential buyers should be reminded that before effecting any transaction, if they're in doubt, they should seek independent professional advice. Mr. Deputy, 8 members have spoken just now. They mentioned the amendment bill as well as matters related to land administration and management. It's not appropriate for me to comment on individual cases. If necessary, members can follow up after this meeting. But for the general points, I'd like to provide a comprehensive response here. Concerning law enforcement, as UUGL at different times and involving different persons as well as different sites, given the present manpower level of the Lands Department, it is impossible to, at designated times, compile a comprehensive record of UGL cases, which are dispersed very broadly within the territory. Regular patrols in terms of use of resources and ancillary facilities is impossible and not cost-effective. Therefore, the Lands Department has adopted a pragmatic approach. That is, upon receiving a complaint or referral from the public, suitable inspection and investigation will be carried out. If any member of the public discovers any UUGL, he is welcome to use the government hotline 1823 or the Lands Department hotline, facsimiles, emails, or other ways and means to inform us. The Lands Department will continue to adopt the risk-based approach to step up patrol on fenced-off sites and sites more prone to UUGL and black spots. They'll enhance law enforcement and patrol. Mr. Deputy, just now, members also mentioned land demarcation. On the 20th of October last year, the Law Reform Commission published a report on laws regulating adverse possession. For land registration and land administration, they put forth some recommendations that's related to land titles and occupation of government sites. I'd also like to add that the Lands Department will review their manpower level and workflow, and wherein when appropriate, review their priorities in law enforcement so as to effectively and efficiently use their resources. In order to enhance efficiency, the Lands Department has already enhanced their training for staff members in terms of patrol, identification, and so forth. The LRC report also made recommendations on demarcation of boundaries. We'll also step up publicity and education to remind members of the public not to take part in UUGL. Just now, members asked whether there were cases of occupation first, legalization later. The government will not encourage such so-called regularization behavior, but the administration will give regard to the actual circumstances. In vetting such cases, we have very strict criteria of vetting. Save for very strong justifications, the Lands Department will not grant STTs for such cases. In fact, in the past, the Lands Department rejected many such applications. As for the regulatory period, when we drafted the amendments in this exercise, we did consider that by enhancing penalty as well as daily fines for continuous breach, it would suffice. For similar offenses, the custodial sentence prescribed by our laws are similar to those in this ordinance. So in future, wherein when necessary, we'll give due consideration to such a proposal. We believe that enhanced penalty will be able to send a message to the public. That is, the government is determined to combat UUGL. I urge members to support the bill. With these remarks, I'd like to urge members to support the bill.
I now put a question to you, and that is that the Land Miscellaneous Provisions Amendment Bill 2014 be read the second time. With those in favour, please raise their hands. Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Land Miscellaneous Provisions Amendment Bill 2014. Committee stage. Council is now in committee. I now propose the question to you, and that is that